Hi class, this is February 11th and this lecture tape covers Chapter 12, the chapter on disclosing and excluding evidence. I think Chapter 12 is probably now the third most important chapter in the book. I talked before about how the prosecutor chapter is really important and also one of the beginning chapters on the general criminal and civil processes is very important. But now we get to, I think, really the machinery of the judicial process, which is this process in which two antagonistic parties are warring against each other, and most of their war is going to be about the access to or the exchange of information. And in our current digital age, that becomes extremely more innovative and intriguing, and sometimes the law is a little bit behind in catching up with the means of exchanging or getting access to information, or sometimes in the case of the Steve Hurley case that I posted, the outright, shall we say, procural of information through surreptitious means. These issues, whether you consider it to be disclosure, discovery, or suppression of evidence, I think are what really makes a case get resolved. Sometimes early, is it what really makes justice happen in a case. So you really want to pay close attention to this, even though there's a lot of different rules and it can be kind of confusing. I would say that there's two general overarching principles in this chapter. First of all, there's the principle that discovery should be more open and should go both ways between parties. This is not governed by any constitutional principle that defines the entire process. There are other principles that make a few important rules along the way of the process, but there's no constitutional right to discovery in a criminal case. This is to be contrasted with a civil case where there's extensive discovery, exchange of information, depositions, the taking of testimony ahead of time. So in the criminal case, the aim, the drive for open exchange has been evolving over time, and that's one of the themes of this chapter, that the Constitution doesn't define it entirely, so it's going to be defined by a lot of rules, state rules, judicial rules, legislative statutes. And so one of the first things that a practitioner does, or a party that's studying the system, is going to notice is every jurisdiction is different, except the federal jurisdiction, of course, is uniform throughout. But every jurisdiction, as you go from city to city, county to county, state to state, you're going to find different rules of discovery, and sometimes the rules of discovery, you have to kind of dig them out from the books, the law books, at all those different levels. When I practiced in Wisconsin, there were different discovery rules at the municipal level. There were different discovery rules for state court proceedings. So the observer, the practitioner, the judge, the police officer, the probation officer should be astute in all these discovery rules, because these are the rules that are going to be determinative of a case. I'll just give you an example before I give you the second point of this chapter. When I was an assistant attorney general with the Minnesota AG's office back in the mid to late 90s, we were marginally involved in that big tobacco case that eventually brought down Philip Morris's illegal practices of doctoring not only their books, but doctoring the chemicals that went into cigarettes for the purpose of sale at all expense. And we were involved in the discovery of that, and at some level that pertained to the state's lawsuit against the tobacco companies that eventually was resolved around that same time period. But I remember going to these huge auditoriums and looking over all these reams and reams of documents and boxes, because there was so much information to go over once we got the discovery order that we wanted. And discovery in that case, disclosure of evidence, was what brought down the tobacco company. There's a famous movie called The Insider that I highly recommend, The Insider, starring Russell Crowe that goes into a lot of those details, those depositions, but mainly the fact that an insider was switched sides from the tobacco company and became a plaintiff's witness, and that testimony became central in not only the private civil case but the public cases that involved the states suing the tobacco companies. If it wasn't for the garnering of that information, that insider, and all the data that he was able to get, much like a WikiLeaks disclosure, there would not have been a tobacco case that was resolved in the manner that it was. Nobody would really know today what the tobacco companies were doing at that time. And so highly recommend the insider, but to the extent that in the criminal process the disclosure can be more open, more fair, more timely, this is one of the overarching themes. And that's rule-driven, statute-driven, and it's not driven by really an overarching constitutional right. No constitutional right to criminal discovery or discovery in criminal cases. That might be an exam question, by the way, because we're going to have the exam that I'm giving you this week. I should have posted it by now, but it's going to be posted very shortly. This exam covers through Chapter 12. So keep that in mind, that the difference between criminal cases and civil cases is that there's massive discovery in civil cases, whereas there's very limited discovery. The model in criminal cases, it depends on an equal exchange of information, the demanding of information, sometimes the bringing of motions to get that information, and sometimes just the discovery process can be dragged out to almost a separate case within a criminal proceeding. But sometimes that results in a more efficient mechanism, because if one party gets information that it needs to prove its point, that can result in the other parties closing down and settling the case. It goes both ways, defense or prosecutor. So that discovery process is really important. Every person that's involved in any particular jurisdiction really needs to know and comb over with a fine-tooth comb what those discovery rules are. I would say that that is the most challenging. I remember that being one of the most challenging parts of criminal defense practice, was just keeping on top of all the things that you needed to know that the other side could have, and the mechanism of getting that to be disclosed, getting that to be admissible in court. Okay. The second overarching theme of this chapter is the due process standards, or the constitutional standards that apply to criminal cases that require either the disclosure of evidence or the exclusion or suppression, as it's called, of evidence. So everything from the Brady versus Maryland case of 1963, in which the Supreme Court held that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecutor. So that's commonly referred to as the Brady rule. So you have the Brady rule, you have a case called Jenks and Giglio. All these cases define when the prosecutor has to disclose information to the defense, and these rules have influenced many of the state rules requiring disclosure. So the defense can make a demand, for example, and impeachment statements must be disclosed. That is, statements that can be used to impeach a witness, videos of that nature as well. Any exculpatory evidence that might result in an unfair proceeding if it were not disclosed. Okay, so there are these various rules, and the overarching theme of many of them is due process. Due process meaning, is there a fundamentally fair process in operation in the trial of the accused person? So, for example, the withholding of evidence in the Duke Lacrosse case, that the witness could not identify her assailants, that became, I think, material that should have been disclosed by the prosecutor. He did not disclose it until later. So that was sort of impeachment evidence, evidence that could result in an unfair proceeding if it were not disclosed. And due process is concerned that both sides, really, the defendant and as well as the prosecutor, because the prosecutor often will argue that it has to have a fair proceeding. Due process means that there are not going to be surprises at trial, That's the theory. Of course, from any person that's involved on the ground in the criminal process, there are always some things that are going to fall outside of the rules of disclosure that can be used by a party to create a tactical advantage. That happens quite frequently. In fact, I don't think my practice would have been as vibrant if I were not holding some cards that I had, including information close to the vest that were not required to be disclosed. So these rules are driven by this idea of constitutionality, due process fairness. Also, the rules concerning exclusion of evidence are controlled by a notion, a constitutional right, having to do with the right to not incriminate yourself. That's drawn out of the Fifth Amendment. That's the famous case in our chapters, the Miranda case, in which the court held that certain advisals had to be given to a defendant prior to a custodial interrogation. That is, an interrogation in which the person is arrested and being questioned about the case and is in a confined space. Certain advisals had to be given in order for that confession, if one was made, to be considered fair. That notion has to do with a person not having to be required to give over evidence against themselves without prior notice about how that evidence is going to be used. And that's the Fifth Amendment. So there's the idea of due process, the idea of the right against self-incrimination, that are the second overarching theme of the case, the theme of this chapter. So keep those in mind, both this idea of fair and free disclosure and the idea of these constitutional rights that apply. I think those are the key factors in this chapter, chapter 12. Now, the discovery rules in criminal cases are driven by local or state decisions to codify norms and basically prescriptions that the discovery process has to occur in such and such a way. I've practiced in jurisdictions where it was what was called an open file discovery process, where the prosecutor would, theoretically at least, and they would actually do it, but the theory was the prosecutor would have a file, the defense would go over there and take a look at it, and everything that was pertinent to the case would be in the file. Okay, now, that's one way of doing it. Another way of doing it is the on-demand system, where you make a discovery demand, and each party makes a demand to the other. The prosecutor demands from the defense demands from the prosecutor. As long as the demand is made and the statute in question governs the material sought, each party has to exchange information. That's another way of doing it. Some states have very limited discovery. Some jurisdictions have very limited discovery. I mean, my own experience with that was traffic law. In traffic cases, the discovery is extremely limited because not as much is at stake. But even states, let's just assume, I think Washington is a state like this, Wisconsin was a state like this, even states where you can demand a broad array of materials be disclosed to your client, if you're the defense, or on the flip side, the prosecution can demand a large amount of information from the defense. A subplot to our chapter is there are a lot of holes in this system. I mean, the text doesn't come right out and say that, but as a practitioner, I can tell you, despite all these rules like Brady, like Jenks, like Giglio, despite the prosecution's right and codified in statute to get information from the defense about statements that are going to be made in court, or statements that have been made that are material to the case, or experts that are going to be used, evidence, videos, tapes. Despite these rules, there's a whole lot of loopholes in which the rules do not cover a particular area. And one of the reasons is that rules just simply cannot handle all the different things that are going on in the case. If you were to prescribe those things, you would have a really dysfunctional system. You can just imagine trying to get a statute together that lists everything, that in order to make in order for there to be established a fair process, completely pure of any mistakes, these codes have to apply. There's no such code that could be developed. It would be laughed out of the legislature, I can tell you that. It would be impossible to draft, in my opinion. But for those reasons, there's a bunch of gray areas, open areas, in which a party on one side or the other, can keep close to its vest and not disclose information to the other side. One example of this that I encountered personally in practice many times, and I had to make a fair judgment about that, about my duties to disclose to the prosecution, was the duty to disclose information of witnesses that were not parties to the proceeding, or witnesses that did not necessarily have information that was going to help the other side, but information that was going to help my side, that in which the other party would be ambushed if I was to bring it into court, and was not covered by the discovery rules. Sometimes that information was so critical to the case that to not disclose it to the prosecution would have been, I think, a breach of protocol, would have resulted in a proceeding that was probably unfair to the other side, because this is information that, for example, in one of the cases I had some witnesses that had seen an event, that had seen it in the way my client had described it, almost to a T. And these were a group of witnesses, probably 2 or 3 of them, and bolstered my client's credibility. The prosecution had not seen this. I was not required to disclose it. I had a choice between leaving that evidence until the very last minute and ambushing the state at trial with these surprise witnesses, or disclosing it in all fairness, not because there's a rule, but because I felt maybe it would sour my relationship with this prosecutor if I were not to disclose, or maybe it would just be fundamentally unfair and waste a lot of time and resources to hold off these witnesses that kind of showed my client was innocent, to hold these off until the last minute, because they could have resulted in the resolution of the case much earlier than a trial. So I had this dilemma. Do I disclose to save the judicial system all of these headaches, and also to save face for the other side, a party that I would have to deal with in the future, and also just because these were facts that should be known fundamentally, witnesses' declarations that my client's version of events was correct and corroborated, with the other side, which is a tactical advantage in the case, knowing that you have 3 witnesses that are going to bolster your side. They are not, these witnesses were not demanded by the state, were unknown to the state. Should I disclose those to the state prior to the proceeding? I ended up not having to make that decision, thankfully, because the case blew open at the preliminary hearing, the probable cause hearing, and I prevailed in the case despite those witnesses. But I was advised by some pretty experienced colleagues that if you got to that point and you had to try the case in an actual trial, that you should disclose that evidence, because of those reasons you're going to have to work with this prosecutor again. The fundamental unfairness of the prosecutor not knowing about these witnesses. The bad police work is not the prosecutor's fault. It's a different agency. The bad police work in not getting these witnesses' statements. It was more a matter of sort of racism that the statements were not gotten. Or just sloppy police work, hysteria, sort of. It was a high-profile case. But the advice was to disclose it. I still had reservations, because my view was that the prosecution's proceedings themselves were unfair, and if they're going to bite out this much of a chunk from a client's rear end, I felt I had a right to also be kind of explosive at the trial with this surprise evidence. The prosecution does the same thing sometimes. The only question is really a gut feeling. Do you think it's right? And that's the gut feeling that I would have had to go with. I probably would have decided to disclose the evidence in that case. But these are the day-to-day decisions that are made in really important cases that will result in a fair proceeding happening, or a proceeding that's kind of dysfunctional. I encourage everybody that's going to be involved in the criminal or civil judicial system that they think long and hard when they get a piece of evidence, much like the movie The Hobbit, The Ring. When you get that ring on your finger, you feel like you have power. But when you get that ring, just think long and hard how you want to use that ring, because it could come back to haunt you if you don't use it in the right way. And go with your gut. The rules may not cover the situation. The rules might only cover a portion of the situation. The key thing is that you go with what you think is right, that is, what you think is going to achieve a just result, both for your client and for the system as a whole. If the system in the case is working in the wrong way and you feel that you need that ring as power on your trial, sometimes that's going to be the right decision. But sometimes the right decision is going to be to relinquish that tactical advantage, because it's untoward. It's taking advantage of a situation. It's two wrongs makes a right. You'll know that based on your gut feeling in a case, and you have to go with that. You have to have courage to go with that. Whether you're a police officer, a judge, a litigant party, you're going to have these decisions, and that's what justice is all about. Whether you disclose that, whether you allow the disclosure, whether you suppress it, whether you pick up the evidence as a police officer, whether you try to get that evidence by shifty means. Always keep that in mind, because that ring will come back to haunt you eventually. It always does. You're only going to get so long where you're skating and you're taking advantage of things. It doesn't last forever. Make sure that you approach a case with an even-handed disposition. So these rules sometimes do not cover matters. I talked before about how sometimes the defense can get access to police reports, or a civil litigant can get access to an insider, as I mentioned in that movie, The Insider. There are ways to get information that are legion, that are not covered in these rules. And I would say that in many of the cases that are resolved in a fair way, the way that information is obtained is somewhat an outlying proceeding, or an outlying exercise, much like that that activity that took place in the Steve Hurley ethics case. I encourage you to read that, because that's an issue of disclosure. When the defense approaches the prosecution, or the prosecution approaches the defense in the beginning of a criminal matter, the watchword is distrust. Okay, remember, one of our themes in this case is this is an adversarial system. This is a system in which you have two parties that are warring, competitive. They want to win. They want to achieve justice, but they're human, so there's going to be this drive to prevail. I think that's an overarching drive. And when that's the case, you have distrust. There was never a prosecutor that I ever trusted, not because I didn't like them all the time or thought they were unsavory, but only because the system is that way. The system is set up so that the prosecution, or on the other hand, the defense, if you're on the opposing side, you should expect a surprise, because that is the way the process is simply set up. It's adversarial. I think there is a question as to whether that's the best process. Many people just assume that it is, but there are other processes besides the adversarial system. But knowing that we're in an adversarial system, there has to be a fine balance between plea bargaining and playing a game of chess in which you are very cagey in your moves, and you're not simply collaborating with the other side all the time, or knowing or exchanging pleasantries with them, and being almost a cog in the wheel. The advocate, whether it's the police officer or the prosecutor or the defense attorney or the defense attorney's investigator, we can get along at times with the other side, but many times we're in an adversarial posture. So the watchword is distrust. So in the Steve Hurley case, that was the beginning of that case. The watchword there was distrust. Mr. Hurley did not believe he was going to be able to get the files from the complaining witness's computer, the 15-year-old, because there's a lot you can do with the computer to destroy information. There was the police that were on the opposite side in a very high-profile case involving accusations of possession of child pornography, future allegations of sexual assault. There was just no way myself as a defense attorney would have trusted the police to just hand over, if I disclosed that I needed that information, that was my defense's position, that we thought that the 15-year-old offender, or not the offender, the 15-year-old victim witness was a person that themselves was collecting child pornography for their own use, as well as the accusations against my client, if I was Steve Hurley. So there's this distrust. That's a healthy position to be in. And that is not a bad thing, because that's what the system is all about. In fact, if you're not distrusting, I would argue that's very unhealthy, that you're not going to provide a very effective defense or prosecution of the state's case on either side. It's that kind of game. Healthy distrust, which leads the police to perform sting operations to get information, which leaves civil litigants to investigate thoroughly witnesses who may be reluctant to come forward, to try to incentivize them to come forward. Sometimes a break will come in the case that the a litigant has no control over, but it's a huge break and they have to take advantage of it. Those sources of information, those witnesses, those documents, those videos, transcripts, those are all things that can result in a resolution of the case much sooner than a trial, much cheaper than a trial. And so the advocate for either side has to be very vigorous in trying to get those pieces of information. In the case of Steve Hurley, that's what he was. He was extremely zealous in his exercise of that discovery principle of distrust and of aggressive, vigorous discovery. What he did there, and you'll see if you've read the complaint, was he sent out an investigator to perform a sting operation or a sting-like operation to trick the victim witness into handing over his computer in exchange for another computer, because the victim witness thought that Steve Hurley was a company that was merely studying computer usages among young people. And so he got that information in a sting-like operation, and the prosecutor was so incensed that they filed an ethics complaint. Eventually, the ethics complaint was dismissed, and the ethics board exonerated Mr. Hurley, and in fact complimented him for providing the most zealous and the only possible zealous representation in a case like that. You will find that that is the case sometimes. Both the police and the prosecution and the good defense attorneys will do those kinds of things. And sometimes that results in a kind of end run around the discovery rules. Definitely in that case, right? I mean, there was not a discovery rule that Mr. Hurley could trust. So there was an end run in which he put together a setup operation in order to get the information that he did not trust would come through the legal system. What he did, was that illegal? It was right on the line of illegality. And both parties do that in specific cases where it's required. I'm not here to necessarily preach for that, but you're going to know those cases when you see them. If you're in a good police department or a good prosecutor's office, you're going to know why it's right to do that in a given situation. And it has to do with when the disclosure of information is going to prejudice your case. If you just disclose that you want something to the other side, or that you're doing something with information to the other side, you can taint a case by doing that. Similarly, the defense can taint their case if they simply disclose that they want a certain piece of information and why. Some things, sometimes we do put that ring on, and we exercise power in a way that makes an end run around discovery rules. That's not going to be in your text, but that's what happens sometimes, and I think the Steve Hurley case is an excellent example of that. I'll put together a form shortly so you can delve into that case. That ends our lecture for today, but keep in mind that this discovery and suppression of evidence chapter is going to be on the exam. Be aware of the Miranda case, the case of Close. In that chapter, that's an important case, and also just the idea of the courts having power to exclude evidence in a manner. I didn't go into that in detail, but that part of the chapter is also important. The rules as to how you are able to suppress evidence and what evidence does not get suppressed. Okay? All right. Have a good day.